our findings and our conclusions that the facts do not support the filing of criminal charges against Officer Darren Wilson in this case. Michael Brown's death, though a tragedy, did not involve prosecutable conduct on the part of Officer Wilson.
All right, folks, joining us now is our friend Kendall Coffey, partner at Coffey Burlington and former U.S. attorney in Florida. Hello, Kendall.
Hey, Steve. How are you today?
I'm great. Snow and all. I know you're in sunny Florida, so stop rubbing it in.
It's beautiful
All right.
here. 87
I
degrees.
know. All right, let me ask you this. I don't even want to talk about the police department, what they found against the police department, because I mean, that's a separate issue. But in announcing that there were no civil rights charges brought against Darren Wilson, and if you read the whole report, their own report says 6 of the most credible witnesses of the shooting of Michael Brown were afraid to give testimony in support of the police because they knew it would undercut the hands up, don't shoot narrative being advanced by the neighbors and by the media. They talked about how they were fear for their lives. They talked about how there were signs in the neighborhood that said snitches get stitches. Shouldn't they be investigating anybody who was intimidating these witnesses? Anybody posting threatening signs?
Well, if they have evidence that anyone was intimidating a witness, we all know that's a crime. It's a federal crime, and it comes up a lot. It's one of the reasons attorneys tell clients who are concerned about an investigation, don't go talking to other witnesses. Don't try to influence them one way or another, because the feds can charge that as a crime of obstruction, and they often do.
All right, so I mean, so they would have to have evidence. I mean, they know there were signs. Like I said, it's in their own report, quoting witnesses by number, of course, not by name, about how afraid they were, and they didn't want to testify. One woman put a couch against her door so that the feds couldn't serve her with a subpoena because she was afraid she'd be killed. I mean, this is bad stuff. And if not the feds, then the media should at least be. They had to know what was going on. They were all planted there for weeks.
But any kind of obstruction investigation has to center on identifying an individually guilty actor. So it's not enough to talk about an atmosphere.
Right.
You have to talk about what specific individual did or said what to intimidate a witness. And without that, there's nothing the feds can do about it other than, raise public consciousness and put it in a report.
All right. How much trouble is Hillary in here? Her supporters are saying, well, she just did what Colin Powell did. I mean, he was but the difference is that there was a new law put into place in 2009, and Hillary Clinton became Secretary of State then. So it doesn't matter what Colin Powell did. Condoleezza Rice, his successor, didn't even use email. So she was the first one really affected by this new law. In your view, from what you know, from what we all know from the news, did she break the law, and how serious is this?
Well, I don't think. I mean, and none of us are experts on this law. It comes up rarely. A lot of us are looking at analysis by individuals such as a former litigation director of the National Archives who said that until the law was really clarified, which is after she left office, you wouldn't have a violation that could be punished or sanctioned in some way. But what I think is striking is that this issue is bringing together some interesting bedfellows, because the liberal part of the Democratic Party would like to see this issue elevated because they're hoping for an alternative to Hillary Clinton. Media in general, whether conservative or liberal, has a real concern when they think records might be made less accessible by any kind of public official. So we note that it was the New York Times, not Fox News, that broke the story original. So I think the media is going to have a continuing interest in this. And then, of course, there are people who simply disagree with their politics are going to want to stay on this. So we're in the first phase of this right now. We're still waiting to see what the explanation is to why this particular approach to email was used. But do I expect any kind of a law-breaking type investigation or development as such? No. Do I think this is going away? I think we're in the first phase. And remember, the next phase, Steve, is going to be what is actually in some of the emails, because there are going to be plenty of people combing through there. And then it's going to get to another phase yet, which is, are there some emails that aren't included? When you look at that landscape, it's not a small plot of earth. it's a widespread horizon that could keep going.
Right. Well, there are FOIA requests that haven't been met. The AP might sue to get information about her relationship, giving Uma Abedin, the wife of Congressman Anthony Weiner, and her longtime assistant, a State Department job. They haven't gotten those documents. Judicial Watch is suing. Other groups are suing. So for Hillary's group to pick out the emails that they hand over doesn't seem exactly good enough.
Yeah, and again, I think both the more liberal elements of the Democratic Party and the media itself are going to stay on this.
Yep. All right, Kendall, great stuff. Thank you for your time, my friend. We'll speak to you soon.
Okay,
Take care. Kendall Coffey, ladies and gentlemen. Up next, Senator John Barrasso will be here on his health care proposal. Don't go away.